In every law enforcement agency here in the Philippines, searching in someone's places or taking someone's property or known as a seizure doesn't begin without presenting the search warrant first to the subject that is intended to be searched. What is search warrant? A search warrant is a legal document authorizing a police officer or other official to enter and search premises. What is the importance of search warrant in every law enforcement agency here in the Philippines as well as the importance of it in every citizen? Search warrant is considered as a foundation of all law enforcement agencies here in the Philippines because it is used to gather all sufficient evidence that can be used for the conviction of organized crime group or suspected criminals. The use of search warrant before searching on subject place or before confiscating illegal things that are stated on the warrant plays an important role in every law enforcement agency operation because it protects the right of the citizen to have privacy, right to be free from unreasonable search and seizure, as well as it also protects the uniformed personnel. It can also help to determine if there are uniformed personnel is abusing their authority or violating the procedures during the conduct of a search or seizure. What is the difference between search and seizure? The search is an act of inspecting a person or places enable for the uniformed personnel to look if there are any illegal things in the subject places that can be used as evidence. The seizure is an act of confiscating illegal things that can be used as evidence for the successful conviction of the suspect. Always remember that seizure is always with search because uniformed personnel can confiscate things without searching the subject place first to find if there are any presence of illegal things. How search warrant is implemented by uniformed personnel. The implementation of the search warrant starts when uniformed personnel knock on the subject place and introduce themselves. If the subject opens the door, they can present the search warrant to the subject. But if the subject refuses to open doors, uniformed personnel may break the door and able for them to enter the subject place. The main reason here why breaking of doors is allowed in every search warrant because there is some evidence that can be solved easily such as illegal drugs. That's why uniformed personnel needs to act fast and able for them to obtain evidence in subject place. During the search in subject place, the uniformed personnel is only allowed to search in the specific area or location as well as confiscating things that is stated in search warrant. But if uniformed personnel found illegal evidence that is not specified in search warrant, uniformed personnel can legally confiscate it and it is known as plain view doctrine. While uniformed personnel searching the subject place, it is important that they have two witnesses that live in the same community with the subject. And if there's no available witness, they can ask the help of the barangay personnel. The time of the search is always daytime except when the search warrant stated that it is allowed to serve during the night. After the successful implementation of serving search warrant in the subject, the law enforcement agency is required to return the search warrant with the evidence that they gathered during the conduct of search in the subject place. If the law enforcement agency has been failed to serve the search warrant after 10 days to the subject, they are required to return it for the judge to know the reason why they can serve a search warrant to the subject enable for them to conduct a search in a subject place. So the question is, what is the uniform personnel violation if they entered someone's places or seized someone's things? According to Section 2, Article 3 of the 1987 Philippine Constitution, it stated that the right of the citizen to be secure in their private property as well as it can be used against unreasonable searches and seizures. If the law enforcement agency violates the right procedure on how to conduct it, they will have a violation of domicile. What are the requirements that the applicants needs to comply and able for the judge to issue a search warrant? The application for a search warrant includes the office name applying for the search warrant, name of the officer applicant, name of the subject, address as well as the place to be searched or the sketch and the specific things to be seized. Section 4 provides for the requirements for issuing search warrant, such as it must be based on a probable cause that must be determined personally by the issuing judge through his/her examination. The search warrant must describe or identify the property to be seized. The search warrant issued must particularly describe the place to be searched and the person or things to be seized. It shall issue only for one specific purpose, and it must not have been issued more than 10 days to the search made. Can the judge still issue a search warrant on the applicant even the application for a search warrant provides only the name of the subject without any other information about the subject? The answer is yes. Why? The judge can issue a search warrant even though the applicant of the search warrant only provides the name of the subject without any other information about the subject that are intended to be searched, because the judge will not only be based on the findings of the applicant. It is considered as enough evidence if the applicant can describe, sketch, identify, provide photographs, or know the place where the subject is located. According to Rule 126, the Rule of Court, Section 4, the judge has a responsibility to conduct the personal examination of the record of the case, as well as he/she have to determine if there's an existence of a probable cause. Also, when the applicant only provides the name of the subject or when the applicant misspelled or provides a wrong name, the judge can still issue a search warrant, because it is enough if the applicant can identify who is the subject for the search warrant and describe the subject's personal appearance. According to Rule 126, the Rules of Court, Section 6, the issuance and form of the search warrant is when the judge is satisfied after examining all the records and determining what there's an existing probable cause. What are the instances when the valid warrantless searches and seizures are allowed? The search made incidental to a valid arrest, a search of moving vehicles, seizure of evidence in plain view when there is a waiver of the right or there is a consented search, searches under stop and freeze rule, emergency and exigent circumstances, routine searches at borders and ports of entry or known as custom searches of businesses in the exercise of visitorial powers to enforce police regulation and tip information. Technical English 1 and Technical English 2 teach me a lot of lessons that can help me to improve my writing skill as well as to be a better person. This course made me realize that being a law enforcement officer has a lot of responsibilities to do. That's why it's really important to improve myself first before serving others by starting to study hard and able to help other people who are in need. This course provided me with the knowledge that I can be used to apply when it comes to writing a police report by being familiarized with a lot of the definitions of the word. Honestly, I consider this course one of the most difficult because I realized that when it comes to writing a police report, it is not just all about writing, because a written police report can give justice to a victim of a crime. That's why I need to put all of my heart and effort when writing it. I learned that when it comes to class grouping is to be cooperative, to have a lot of patience, and I realized that there's nothing to be afraid to ask for help from others. I know that time will pass and I will forget the lesson that Mama Ngibin shared with us, but the values that she instilled within my mind are more important to me. I realized that being a good person at all the time is important more than my academic ability, because Mama Ngibin made me realize that it doesn't matter if you are not smart enough, but you can be a better or a good person if you choose to be.
This topic is about police blotter. Police blotter is a record of daily events occurring within the territories, jurisdictions of a given police unit or command. It contains materials details concerning the event for legal and statistical purposes. Therefore, it is an informational record book that is utilized for event, evidentiary, or referral purposes. This police blotter, it contains the daily register of all crime incident reports and the official summary of arrests and other significant events or activities that reported in the police station. Next is e-blotter. E-blotter is an electronic blotter system for recording crime incidents across the country. It does not facilitate crime documentation and modernize data documentation. Reliability is storage for quick reference and hassle-free transmission of data to the end recipient of all police reports at Philippine National Police National Headquarters. This e-blotter is a system that set a standard procedure by which all crime incident report that happened in the police station are electronically stored in database. Next is the procedure. This is the procedure for recording incident report in the police blotter. First for the procedure for recording incident report is the manual recording of the crime incident report from the IR to the police blotter. The crime incident report recorded in the IRF after the transaction with the reporting person has concluded shall be transcribed and entered into the police blotter by desk officer of the police station. For those police stations equipped with the crime incident report system, popularly known as the e-blotter, the designated crime register will likewise enter the record in the system. And for the number two, procedure for the recording incident report, is the importance of the police blotter. Blotter entry reports serve as permanent record of incidents, events, problems, and so forth. There are many types of reports, each of which serve different functions. A police blotter is used to keep people informed of activities within the police jurisdiction. It also used to compile statistically information, identify problems in the community, or identify police training needs. These reports are needed to facilitate investigations. And for the number three of procedure for recording incident report is basic guidelines. In basic guidelines, the narrative written in the IRF shall basically be the record that shall be transcribed in the police blotter. While it is in a narrative form, it is imprudent, however, to list down some necessary information in the police blotter in itemized or outline form. This shall answer the necessary requirements of 5 Ws and 1 H. In taking a police blotter, the important part there is that we should gather the 5 Ws and 1 H. The 5 W and 1 H is who question. These are questions used to inquire on the identity of the victims or offended party, name of the suspects and accomplices, accessories and witnesses of the crime. Next is when. When question. These are questions needed to determine and fix the time, day, month, and year when the crime was committed. When questions should be specified and as accurate as possible. Where? Where questions. These are questions that answers the place of the incident, the city or town. the direct or barangay, the street or road, at the number of the house or building. Where questions are necessary in specifically pinpointing the particular location of the crime scene. What question? The purpose of these types of questions is to find out what happened or what took place before, during, and immediately after the commission of the offense. And why question? These are questions that endeavor uncertain and the motives, causes, antecedents, previous incidents, related facts, background occurrence that might help explain the commission of the offense. And lastly, the how question. These are designated to help the investigator determine how the crime was committed. The means or tools are employed, the crime was discovered, and the culprit enters the building room. How questions are very significant in preparing the modus operandi file or report. Affixing signatures and contact details. As soon as the incident transcribed in the police blotter, the desk officer and the reporting person shall sign in the police blotter. It should indicate under the name and signature of the reporting person his address, home, telephone number of phone, and identification card presented. In event that the reporting person indicates that he does not want his contact details to be recorded in a public record, as the police blotter, by reason of privacy, the same should not be recorded. As a matter of respect to the said person rights, but it should, however, be indicated in the IRF. That's all. Thank you.
Spot report. A concise narrative report of essential information covering events or conditions that may have an immediate and significant effect on current planning and operations that is afforded the most expeditious means of transmission consistent with requisite security. It is also called spot rep. Spot report, also found in acronyms, a concise narrative report of essential information covering events on conditions that may have an immediate and significant effect on current planning and operations that is afforded the most expeditious means of transmission consistent with requisite security.
Homicide is when other person killed a human being, whether purposefully or accidentally. It is referred to as homicide. Other form of homicide is the moderate to reduced level of intent. Manslaughter, reckless homicide, negligent homicide, and vehicular homicide are among them. In rare situations, a killing is classified as a legal justification for self-defense or other reason, and it's not prosecuted. Families who have lost a loved one can seek compensation outside of the criminal court system. This takes place in civil court which are wrongful death lawsuit. In this article, discuss type of homicide when a homicide is considered legally justified and when one could face civil liability from a wrongful death. It explained that many sorts of homicide. When a homicide is regarded legitimate and when a wrongful death may result in civil liability. Other reason why homicide being committed because of anxiety, despair, PTSD, anger, guilt, and sense of vulnerability are some of the psychological repercussions. Homicide can also force family to pay for things and illegal expenditures and person cannot afford. They can be triggered of a person anger and out of control because of emotion and pressure. Homicide, the killing of human being by others. Homicide is a general term may refer to a non-criminal act as well as the criminal act of murder. Some homicides are justified, such as killing someone to prevent the conduct of a serious crime to assist the law enforcement officer. Other homicides, such as those committed in self-defense, are said to be excused. A criminal homicide is one of the justified or excused by the applicable criminal legislation. All illegal systems make important distinctions between different types of homicide, and punishments vary greatly according to the intent of the killer, the dangerousness of the killer's conduct, and the circumstances of the act. In R249 homicide, any person not coming under the term of Article 247 shall kill other without the attendance of any of circumstance specified in the next previous article, shall be held guilty of homicide and be punished by reclusion temporal. A person was killed by the accused without any justification, and the accused intent to kill, which is presumed, and the killing was not accompanied by any of qualifications circumstance of murder, parricide, or infanticide. Thank you.